let me just show you. I understood that I know that they've sent around like the student surveys of alcohol use. This is one that we've blocked out the name of the middle school and the high school to protect the innocent. But this is a survey that was done at an area high school and middle school, and I just find some of the statistics, you know, especially the pink middle school, because my 13-year-old is an 8th grader now, so I'm looking at that particular number where 20% of middle school kids had used alcohol. You're talking about even 4% having done binge drinking, and I just found this particular slide very, very surprising, and I know that there's been a survey sent out amongst students here in Nantucket. I think what I found more surprising was the next slide, because what they did was then send basically the same type of survey to the parents of these same children. So now you've got, you know, 80% of high school kids and 20% of middle school kids saying, yes, I've had alcohol before in the past. And then you've got, my child does not use regularly, has never used drugs, 83%. So, you know, it's one of those, either they don't know what's happening or they just don't want to admit it's happening type survey. But I just found, you know, that either the kids are lying or the parents don't know what's going on. But it's kind of it may be a combination, I don't know. But I found it to be an interesting statistic. So the question became then, for this particular high school school system, where were they getting the alcohol? And this was this particular survey, and it just kind of gives you a sense of where they're getting it. You know, 50% might be, you know, as the chief here mentioned, that shoulder tap, hey, can you do me a favor type incident. But this is generally just kind of gives you a general sense of where these children are getting the alcohol. You know, one thing you talk about here is a potential criminal record for these kids. We know that getting into college nowadays is extremely competitive. You know, more and more kids are applying, and schools are looking closer and closer and closer at who am I going to admit, who am I not going to admit. And one of the things that and before I get into your school application, this one, when we do a program that sometimes, you know, and I think I see a lot of Nantucket students here, but when we have them where a lot of the students have to go, and you get a lot of the athletes there, and you tell them that if you're caught at a party with alcohol, not even if you're even drinking, but if you're caught at a party with alcohol, there are some schools that will follow the MIAA guidelines and will take away a quarter of your games. That's a minimum. So if football is 10 games, you know, taking away a quarter of those games to an athlete sometimes can really hit home. Now I live in the town of Norwood, and I know that I believe we go at 50% for the first violation of MIAA rules, and then the second one is you lose the season completely. I don't know what the standard is down here in Nantucket, but sometimes if you present this particular, you know, scenario to a student athlete at a school, and you say, look, you know, you get caught, this is going to cost you some time, you know, playing against the Vineyard, then they're probably going to take that, you know, fairly seriously. And again, it's just a minimum standard, as it says down here. If you highlight it, we kind of pull up it's just a minimum standard. Regards to quantity, use, consume, violation there, as I mentioned, is 25%, 60% for a subsequent. Those are all minimum. A school can choose to go even further than that. One thing, as I mentioned, is, you know, in terms of then leaving Nantucket High School and going on to college, there certainly is a lot of competition for these particular spots at various schools. And you're going to find, as you prepare those applications for schools, that a lot of them, and if you just go on a couple we'll talk about, Here is an application. I think this might be Boston College, but if you hit the next one of the questions that is always asked, have you ever been convicted of a misdemeanor, felony, or other crime? So if you've got two students that are equal, you know, drama club, great grade point average, played on the women's basketball team, but was convicted of a crime, versus that exact same student who doesn't have a criminal record, if I've got one spot, I may have to look twice at the student that has the criminal record. Now let's say you get into Boston College and you decide then you want to go to law school, and first I would recommend highly against it, but if you decide to go anyway, and let's say you decide to apply to Harvard, so obviously you did very well at Boston College, the same thing, and you pull up here, you're going to see, have you ever been convicted of a felony? Have you been convicted of a misdemeanor? Again, Harvard, many law schools are certainly extremely competitive, and this is something that can tag along with you for quite a while. So let's say you don't heed my advice and you decide to go to Harvard and you decide to graduate from Harvard. Then next thing you probably want to do is you're going to want to actually apply to be a member of the bar here for the state of Massachusetts. And the exact same thing is going to be asked of you if you've ever been convicted of a felony or misdemeanor. So it's something that can follow somebody for essentially forever. One of the things that I think, as I mentioned at the beginning, our firm doesn't do criminal work, but we do some civil work. And I want to kind of conclude by telling you that, you know, there's a reason we talk about these particular tragic events. One of the things that you've got to be aware of is that a violation of the social host liability statute could certainly lead to a case against you of civil liability. Now, in the civil liability world, there are certain elements that one has to prove in their case, and there are 4 of them, and there they are: duty of care, a breach of that duty, approximate cause, and damages. And as a lawyer, as a plaintiff's lawyer, now I do defense, so I don't particularly care for plaintiff's lawyers, but as a plaintiff's lawyer, you've got those 4 particular burdens that you need to prove in order to hopefully have a jury render a judgment in favor of your client. Now, in the civil context, a violation of a statute or an ordinance is evidence of negligence per se. Okay? So what that means is if you are found guilty, or if you found that you've actually been charged with a violation of the social host liability statute, that in and of itself is per se evidence of negligence. And so what that means is if I've got somebody who has violated a statute, for example, the social host liability statute, I have now met the first 3 burdens. I have met my duty, my breach, and my proximate cause. So all that's left for me as a plaintiff's lawyer, if I were one, would be to prove damages. And so I think what I've got here, as mentioned, this is a jury instruction that a judge in a civil case can offer up to a jury when they get ready to decide a case. Now, not only is there that particular civil aspect to it, there is also basically the timing and the sequence of everything. A criminal case can probably be opened and shut within a year's time. Probably less. You've got the constitutional right, as we all know, to a speedy trial. Unfortunately, that constitutional right does not apply to a civil matter. And the next one will just kind of show you basically kind of laying out exactly what sort of time frame. I mean, there are cases up in Suffolk County, which is Boston, which are probably older than 5, 6, 7 years old. So this is something that, while there may be a criminal portion to it, which is over and done within the first 3 to 4 months, you're talking 5, 6, maybe even further, time, money, having to deal with this particular issue. So the question then becomes, well, what would something like this cost? And we put together this next little PowerPoint here. Was somebody wanted to have a particular party, so we threw in for whatever the beer would be, the pizza and whatnot. And then we added one more particular item that you might want to think of in terms of budgeting for the party. which would be the civil judgment of $8.6 million. And, you know, that's not just a number that we kind of pulled out of thin air. If we go to the next slide, let's go back to Mr. Neerman that we talked about, where the two young people were walking along the side of the road. Well, recently, a jury in Essex County came back with that particular verdict. You can see the next one. There it is right there. Now, one thing I want you to kind of take a look at is the caption, which is the plaintiffs versus defendants. That's the caption. And you'll see up there that there is Mr. White, that was the driver we talked about. And then there's also something called Gateway Liquor Store. Well, Gateway Liquor Store was the beer establishment that Mr. Neerman, at the age of 19, bought the beer from in the first place. Okay? So the parents of these two individuals sued not only Mr. White, but the beer store, because that's where the beer came from. And so they, having sold it to a 19-year-old, were in violation of the law. Now in Massachusetts, we've got what's called joint and several liability. And what that means is that if a jury finds you, Gateway Liquors, 1% at fault for the accident, the plaintiffs may recover 100% from the liquor store, and then let the liquor store try to get 99% from Mr. White. So if you think about it, let's say Mr. White had been at your house, had left and struck two people. And so the plaintiffs decide to sue Mr. White and decide to sue the homeowner. Chances are you as a homeowner have a few more assets than Mr. White at the age of 18. The reason we bring this up is because you may go, look, I was only 1% at fault for this, so I should only pay 1% of $8.6 million. It's not the way it works. The way it works is that plaintiff's attorney, if he or she chooses, can get the $8.6 million from you, to the extent you have it, and then let you try to do and get what you can back from Mr. White.